The tribunal, all rise.
Will the registrar please call the application?
The tribunal has before it an application for deferral by the Federal Republic of Germany in the matter of Duško Tadić, also known by the names Dušan Dule Tadić.
Will learned counsel please make their appearances?
Your Honours, I appear as prosecutor with Mr. Blewett, the deputy prosecutor, and Mr. Neiman, the senior prosecuting attorney.
Ich erscheine als Amicus Curiae für die Bundesregierung.
I appear as amicus curiae for the federal government of Germany, of the Federal Ministry of Justice. I'm accompanied by the representative of the Ministry for Foreign Affairs and from the Ministry of Justice.
Ich komme ebenfalls als Amicus.
My name is Grimmich. I also come as amicus curiae and am a co-defender on behalf of the Federal Republic of Germany on behalf of the accused.
Will the prosecutor now present his application?
Your Honours, in the aftermath of the horrors of the Second World War and the trials by the victorious powers of the Nazi leaders at Nuremberg, it was generally anticipated by the international community that a new era had begun, an era in which the human rights of all citizens in all countries of the world would be universally respected. It was not to be. The past 5 decades have witnessed some of the gravest violations of humanitarian law. Those responsible have too frequently escaped trial and punishment by national courts. Indeed, in many cases, they have been in positions of leadership and power in their own countries, and they have effectively placed themselves above the law. There was no mechanism devised by the international community for establishing the guilt of perpetrators and punishing them. Justice was denied to millions of victims of murder, disappearances, rape, and torture. A catalogue of these gruesome violations of international humanitarian law is to be found in the annual surveys produced year after year by some governmental and intergovernmental agencies and by national and international non-governmental organizations. This tribunal is the first attempt by the United Nations to enforce international humanitarian law. It is the first recognition of the reality that if international criminal law is to have relevance and is to command respect, it must be capable of enforcement by the international community. This remarkable step by the United Nations is the consequence of events in the former Yugoslavia since January 1991. In describing these events in a provisional order which was granted by the International Court of Justice in The Hague, the judges referred to the words of the General Assembly in a resolution of the 11th of December 1946 in the context of the Genocide Convention. It was there stated that the conscience of mankind is shocked by the events and they are contrary to moral law and the spirit and aims of the United Nations. Your Honours, the proceedings today constitute the first public hearing by a trial chamber of this tribunal. The application is brought pursuant to Article 9 of the Security Council Statute, which confers upon this tribunal not only concurrent jurisdiction with all national courts, but primacy over them in respect of both the investigation and prosecution of persons whose alleged offences fall within the competence of the tribunal. In terms of Rule 9, the prosecutor is given the authority to apply to a trial chamber for the issue of a formal request that a national court defer an investigation and prosecution to this tribunal. In the present case, we rely upon the provisions of Rule 9.3, which provide that such an application may be made by the prosecutor where in the national investigations or in criminal proceedings instituted in a national court, I quote, what is in issue is closely related to or otherwise involves significant factual or legal questions which may have implications for investigations or prosecutions before the tribunal. Your Honours, when I took office on the 15th of August of this year, lawyers and investigations in my office were already occupied with an investigation into allegations of serious violations of humanitarian law in the Prijedor region of Bosnia-Herzegovina. The allegations came from a number of sources, including the report of the United Nations Commission of Experts established pursuant to Security Council Resolution 780 of 1992. The Deputy Prosecutor, Mr. Blewett, became aware of the arrest in Germany of Tadić. The German authorities were subsequently requested to provide the prosecutor with all relevant information concerning the investigation into crimes allegedly committed by Tadić in Prijedor. The German authorities complied with that request and provided my office with relevant information. In addition, statements have been obtained by my office from additional witnesses who are presently in the Netherlands, Norway, Sweden and Switzerland. My office is furthermore in possession of documents relevant to the events in Prijedor and in particular the allegations against Tadić. I am presently considering the issue of one or more indictments against individuals who were involved in the serious violations of humanitarian law in Prijedor. As appears from the declaration of Michael Keegan, which is attached to my application, a policy was executed in Prijedor which involved the widespread and systematic persecution of the non-Serb and particularly the Muslim community, a policy which has commonly come to be described as ethnic cleansing. According to the report of the Commission of Experts, over 43,000 of the approximately 50,000 Muslims who lived in Prijedor in 1991 have left Prijedor or had been killed by June 1993. Witnesses available to the prosecution are able to describe the events which led on the 30th of April 1992 to the overnight seizure of power in Prijedor by Serbs and the announcements broadcast on local radio to the effect that the area was thenceforth to be called Srpska Opština Prijedor. Serbian flags were flying on all official buildings and all non-Serbian officials, including policemen, were dismissed. 3 major concentration camps, as they are referred to, logore, were set up in the Prijedor area in Omarska, a former mine complex, Karaterum, a former ceramics factory, and Ternopolje, a complex of several buildings. At Omarska and Karaterum, mostly male members of the non-Serb population of Prijedor were incarcerated, most of them between the ages of 16 and 60. Many leaders and prominent citizens in the non-Serb population were taken to Omarska. women were generally taken to Pernopolje. The serious atrocities which allegedly were carried out at the three camps are described in some detail in the declaration of Mr. Keegan. They are such that, in our opinion, if they are proved, the persons who ordered the atrocities and those who executed them are guilty of serious violations of humanitarian law and have committed offences which fall within the jurisdiction of this tribunal. I regard it as my duty as prosecutor to issue indictments against such people if their involvement in these events can be proved by sufficient evidence. The investigations in this regard are still ongoing. I come now, Your Honours, to the case against Tadić. Again, as appears from the declaration of Mr. Keegan, my office is in possession of witnesses' statements which directly implicate Tadić in some of the atrocities committed in Prijedor. The allegations against him are as follows. He was involved directly in the events which led to the removal of the majority of the Muslim population in Prijedor and effectively the destruction of that community. The first of them, according to witnesses, was the organisation of the Serbian referendum in November 1991. Tadić helped create what were in effect death lists of Muslim intellectuals and other prominent citizens of Prijedor. He was involved in the forced removals of Muslims from the villages of the Prijedor region and the looting and destruction of Muslim houses. I would emphasize that according to eyewitnesses, when he participated in those events, Tadić wore a military uniform and was apparently in command of a group involved in the actions. Again, eyewitnesses are able to testify to Tadić and the group under his command summarily executing unarmed non-Serbs. He was directly involved in directing the transfer of non-Serbs from the villages in the Prijedor region to camps. He was involved in the assaults of prisoners at the camps and at the military barracks in Prijedor. He was seen on numerous occasions in the Ternopolje camp and at Amarska camp. There is an allegation that Tadić was involved in incidents of rape at Amarska, and that is being investigated. The gruesome nature of the events which witnesses can describe is illustrated in the following extract from the affidavit from the declaration of Mr. Keegan. I quote, "Among the most widely witnessed events that Tadić was involved in was the murder of Emir Karabasic, Yasmin Hernic, and Enver Alic. 3 prisoners were brutally beaten and tortured by Tadić and others using metal rods, truncheons and knives to the point of unconsciousness. Tadić then forced a 4th prisoner to drink motor oil from the garage and then bite off the testicles of the unconscious prisoners. The prisoners died as a result of their torture. Your Honours, I would also emphasize that Tadić was not a regular official at any of the 3 camps to which I have referred. It appears that he was in a position of some leadership in the area, in the Prijedor region, and was involved in directing the activities of those with him on his visits to the camps, as well as the activities of the regular camp officials. I submit that the evidence of eyewitnesses, if accepted by a trial chamber of this tribunal, will make Tadić guilty of some of the most serious offences falling within the competence and jurisdiction of this international tribunal. We anticipate that within a short time indictments will be submitted by the prosecutor to the registrar against Tadić and other persons who have been identified as having been involved in the ethnic cleansing in Prijedor Opština. In support of such indictments, I will rely on the evidence of the witnesses located by the German investigators in Germany and other witnesses who have been located and interviewed by members of the staff of my office in Germany and elsewhere. The indictments will include serious offences in respect of which the German authorities have no evidence, and the other accused will be persons who are outside Germany. It is not possible during this application, which is in public, to disclose details of the investigations undertaken by my office, nor is it possible to disclose the identity of other persons under investigation and who are likely to be included in the indictment or indictments which will follow. I can say, however, that the involvement of Tadić in the factual circumstances under investigation by my office is very significant, and it will adversely affect the investigation and prosecution of other individuals if Tadić is prosecuted and brought to trial in Germany. We submit, therefore, that having regard to the scale and nature of the atrocities alleged to have been taken, which have alleged to have taken place in Prijedor, and the relevance of those events in respect of ethnic cleansing in Bosnia-Herzegovina, this tribunal is the proper forum, and we would submit the only proper forum, for trying those accused, including Tadić, of playing leading roles in respect of those events. It would certainly not be convenient or in the interests of justice if Tadić were to be tried in Germany, only to be indicted and again tried in this court. The legal issues which will arise in a trial of Tadić are central to the jurisdiction of this tribunal. They will involve issues of international humanitarian law which are applicable to the crimes alleged and the nature and manner of their proof. So both substantive and procedural legal issues which would arise in a trial against Tadić will arise in a case against those who acted in concert with him or acted in pursuance of a common policy. The factual issues speak for themselves. The events in Prijedor during 1992 form a very important area of investigation by my office. It follows very clearly in our submission that the Tadić investigation by Germany concerns an issue closely related to and involves significant factual legal questions which will have implications for investigations currently undertaken by me. The Tadić case therefore falls within the provisions of Rule 9.3 and in terms of Article 9.2 of the statute and Rule 10a, this Chamber may issue a formal request to Germany that its national courts defer to the competence of this tribunal. Your Honours, until an indictment has been issued against Tadić, a warrant for his arrest cannot be issued under Article 19 of the statute. However, to the extent that it may be or become necessary, as prosecutor I am authorised by Rule 40I in a case of urgency to request any state to arrest a suspect provisionally. I will therefore request Germany to effect the provisional arrest of Tadić if that is considered necessary by me for any reason prior to the issue of an indictment. We request therefore an order for the deferral by Germany and by the German courts to this tribunal. Your Honours, the basis of the application, and in the application that was handed to the registrar some weeks ago, and in consequence of which this sitting of this trial chamber was arranged by the President, the basis was that the German authorities were conducting an ongoing investigation against Tadić. During the course of yesterday, the press officer of the tribunal, Mr. Chartier, brought to the attention of my office a report from a German press agency, Deutsche Presseagentur, to the effect that yesterday Mr. Tadić was in fact indicted before a court in Germany. My friend, Mr. Yugoslavia, who appears for the federal government in Germany, confirmed the correctness of that allegation this morning. In order to bring the application correctly within the factual situation, we have prepared an amended application which records the fact that Tadić was indicted in Germany on the 7th of November 1994, and I beg leave to hand up the new amended application. The relief claimed in the application is clearly not different in any way from the relief claimed in the original application, and that relief, Your Honours, is that the a formal request be issued by this chamber for the deferral of the Tadić proceedings by Germany pursuant to Rule 10 of the rules, and we accordingly move for such an order.
Now, I have heard your submissions, and I've also read the application and the declaration. I'm only intrigued about one issue, and that is the question of the offenses for which Tadić was indicted or accused in Germany have been fairly stated in summary. But the events in Prijedor, for which you now are asking for the deferral, appears not to have been related to the events for which he was charged in Germany. But I agree, it comes within subsection 9.3, where the matters which you claim that they are related or otherwise involve significant factual or legal questions which may have implications for investigations. I think that ties up with the events which were indicated in Prijedor. But I think perhaps one would have liked to know what were the significant facts in the German jurisdiction which raised these allegations or suspicions.
Your Honor, the facts on which the German authority is prosecuting Your Honor, the facts on which the German prosecuting authorities have indicted Tadić are clearly not known to us. Until we received the information yesterday, we knew of the investigation by the German authorities, and we were grateful and are grateful to our colleagues representing and involved in the Tadić investigation in Germany for having given us the factual information which they have against Tadić. We haven't investigated, and nor would it be within our competence to investigate, the municipal law of the Federal Republic of Germany under which Tadić can be charged under their municipal law. Our understanding is that certainly one of the charges brought against Tadić is the genocide law of the Republic of Germany, which may or may not coincide with the provisions of the International Genocide Convention. But with respect, if Your Honour requires or requests information about the nature of the charges preferred against Tadić, that is a matter which should be, which is within the knowledge and competence of our friends representing the Federal Republic.
Monsieur le Président, Messieurs, d'abord je ferai une observation.
President, gentlemen, first of all, I would like to make an observation which deals with form, but this will not surprise you coming from Judge Jorga. Mr. Prosecutor, you have modified or amended your application, and I would like to obtain a French translation of this, as French is an official language of the tribunal. As far as I am concerned, Mr. President, I would rather ask the few questions that I wish to ask once the representative of the government of the German Federal Republic will have made his statement, and also once the pro bono representative of Duško Tadić will have spoken as well.
May we hear the representative of the federal government of Germany?
Eure Ehren,
Your Honor,
die deutsche Bundesregierung
the German
hat
federal
bei mehreren
government
Gelegenheiten
has
unter Beweis gestellt,
demonstrated on
dass sie
several
die Arbeit
occasions
des Internationalen
that
Strafgerichtshofs
it will
nach Kräften
lend its full support
unterstützen will,
and wishes to lend its full
wird dies
support
auch
to the work
weiterhin
of
tun,
the
soweit
International
es
Criminal
in irgendeiner
Tribunal,
Weise rechtlich
and
möglich
it
ist.
will continue to do so
Und
in
wird
so
in
far as
diesem
this is
Rahmen
legally
Ersuchen
possible.
des Gerichtshofes
And
und der
in this
Anklagebehörde
connection, it
nachkommen.
will comply with any requests
ich gehe
made
von dem
by, within their
Antrag
competence by the
auf
tribunal
Deferral
and its
aus, der
prosecution
Ihnen heute
authority.
vorliegt, in seiner
I
modifizierten Form.
base myself on the
Und
request for
möchte dazu
deferral, which you
grundsätzlich
have in
auch
front of you
bemerken,
in its modified form.
dass die
And I would
zuständigen
point
deutschen
out also
Behörden
that the
im
relevant
Rahmen
German
dieser
authorities,
Pflichten, die sie voll anerkennen, alle bereits angefallenen und zukünftig
within the framework of all the duties
im
which they
Verfahren gegen
recognize,
Tadić
will transfer
Verfahren
all
lässt der
the
Generalbundesanwalt
knowledge
der
gained
Bundesregierung
from the
Deutschland
Tadić
führt,
procedure carried
dem
out by the
Gerichtshof zur
Federal
Verfügung
Republic
stellen werden,
of Germany, and will
weiterhin
make this available to the
einschlägigen
tribunal,
Ersuchen des Gerichtshofs entsprechen
and
werden.
further
Und bei der
requests by the
Weiterführung des
tribunal will
deutschen
also be complied
Verfahrens
with, and in
darauf
the
Bedacht
further
nehmen werden,
um,
dass die Ermittlungen des Gerichtshofes
continuation
nicht
of the
beeinträchtigt
proceedings in
werden.
Germany, we will take care that the investigations of the
Justice
tribunal
Goldstone
should
hat
not be
bereits
adversely
Bezug genommen
affected.
auf die Entwicklung, die
Justice Goldstone
seit
has
gestern
already
sich in einer Einzelheit
referred
verändert hat.
to the events which made changes
bestätigen,
yesterday,
dass
and
der
I may confirm
Generalbundesanwalt
that
beim
the
Bundesgerichtshof
Federal General Prosecutor
mittlerweile die Anklage im deutschen
at
Verfahren
the
gegen Duško Tadić erhoben
Federal
hat.
Court has
Mir liegt
instituted
genau wie
proceedings
dem
against
Generalbundesanwalt sehr
Tadić,
daran,
and
auch hier noch einmal
it is
festzustellen,
my
dass
fervent
dieser
wish
Akt in keiner
to
Weise
confirm, as it is that of the Federal Prosecutor, that this is in no way intended to disturb or counteract the proceedings of the tribunal. On the contrary, this act, which has been undertaken within the framework of the German federal procedure, and had to be taken in order to secure the fact that Tadić could remain in detention within the German proceedings. The investigating judge at the Federal Court will report in 1.5 weeks on and decide in 1.5 weeks' time on the continuation of the detention. And for this, it was necessary that German investigations continue to be conducted with the speediness which is required by the German criminal procedure. And I emphasize that this is in no way meant to constitute an obstacle or a reason to believe that the investigations of the German authorities and of the German court would in any way overlap with yours, or that they could adversely affect the proceedings and investigations of the tribunal in any way. The issuing of the order for arrest, which would be necessary in order to secure a transfer, cannot yet be issued according to German law at the present time. Germany has, again with the appropriate speediness, been preparing a legislative procedure, a bill, which will lead to the fact, when the relevant authorities have approved this bill, that such warrant for arrest and a warrant for transfer will be available, so that the duties arising from Resolution 827 of the Security Council will be fully complied with. I would point out that we've already we are able to comply with most of the duties arising from this, and further duties arising from this we will be able to comply with when the law has come into effect. In spite of the fact that the legislative period ended in October in the Federal Republic of Germany, nevertheless, on the 26th of October, just after the start of the legislative period, the bill was presented by the government, which, if you wish, can be made available to you, and it was decided on by the Federal Cabinet. And again, this is something new I can tell you today. On last Friday, this bill was put before the second chamber of the German Parliament, the Bundesrat, with the addition, which is possible according to German constitutional law, that this bill should be regarded as being in need of particular speed, so that a shortening of the terms of the legislative procedure is possible. Probably the bill will be put to the Bundesrat on the 25th of November, and then it will be dealt with all the other authorities, with all the speediness which German law allows, and we hope therefore that this act will become effective as soon as possible, and then the last obstacle will have been removed, which stands in the way of a full compliance with our duties. I would stress that the compliance with the request by the tribunal, including that which is contained in today's application, does not raise any legal difficulties for the federal government. Thank you.
Any other contributions from the observer? You might ask your questions. Any questions? Yes, let's hear you.
Hohes Gericht, meine Damen und Herren, aus der Sicht
Your Honours, ladies and gentlemen, from the point of view of Tadić's defence, I would like to express my position as regards the statements of the prosecutor as well as those of the representative of the Federal Republic of Germany. First of all, there are no objections on behalf of the defence and Mr. Tadić against a transfer of the deferral of the investigation procedure by the tribunal insofar as the legal conditions can be created in Germany. As regards the individual indictment addressed to Mr. Tadić, I cannot yet express a position except that he contests all the points. A substantive objection is not yet possible because the statement which we received from the Federal Republic of Germany has been much expanded from the warrant which we received in February, and as the defence has not yet had full insight into the documents given to them by the German authorities, access to documents was allowed in the summer 1994, and proceedings took place in October 1994. As regards the accusations by the United Nations, which are more extensive than what the Federal Republic has alleged, we have not yet received any information, and therefore we cannot express an opinion as to the various facts of the accusation. But I would say that there are no objections against the transfer of the proceedings to the tribunal.
Monsieur le Président, avec votre autorisation, donc, je voudrais poser
Well, Mr. President, with your permission, on behalf of the Tribunal, I would like to ask a few questions both to the prosecutor and to the representative of the German Federal Republic. Perhaps I will first address my questions to Justice Goldstone, the prosecutor. The first question, which I will expound on. Mr. Prosecutor, you have placed your request on the basis of Article Rule 9, and I would like to remind you that Article 9, or rather, on the basis of primacy of a national court, can at any stage of the procedure formally request national courts to defer the competence of the International Tribunal in accordance to present statute and rules of procedure. So you have situated your request on that basis of that article, and which requires that you demonstrate that the object of the procedure followed in Germany against Mr. Duško Tadić must deal with factual or legal questions which may have implications for the investigation. And in the course of your presentation, you have indeed demonstrated that there were various factual and points of law. But I would have a few additional questions to ask with relation to what you have said. In the investigations about Prijedor, if I understand what has been said, the prosecutor's office has undertaken a series of investigations concerning the facts and events which have taken place in that area of Prijedor. I understand, Mr. Prosecutor, your concern for confidentiality and secrecy with relation to ongoing investigations. However, I feel that given the fact that you have based your request on Article 9 rather than Article 8, I believe that the tribunal, since we are in a universal state of law, which is the basis justifying our existence, means that we must comply with our own rules. And thus, concerning Prijedor, I wish first of all to ask a few questions. And again, if you are unable to answer, I will certainly understand. The tribunal will understand this as well. But I think it is necessary for the purpose of having a clear debate. You've given a series of testimonies which are coded, I understand this, but according to what you have said, these seem to be testimonies made by foreign nationals with relation to the or presumed or alleged victims or the country itself. So are they members of the UNPROFOR forces? Are they members of the United Nations forces or humanitarian organizations? We don't know. Could you give us clarification? Also, concerning incriminations on the Tadić case, I can understand that you cannot give us a determination since this is still in the hands of German justice. I would like to know at present what are the specific incriminations with relation to our brief. Yesterday, and day before yesterday, you publicly mentioned an indictment with a series of charges, and I think that it would be good at the tribunal level to be aware of the charges. I'm speaking of the full range of these charges, if possible. And again, on Prijedor, since we're dealing with factual issues, I would like to ask you, what is the status of the investigations concerning Prijedor? What progress has been made? These questions are directly related to our debate, since you need a deferral of the Tadić case. I would like to know if Prijedor is in a state of investigation which has reached a point where you do need this, or if you are, in fact, at an initial stage of your investigation. In other words, do you need Tadić immediately, now at the beginning of your investigation, or is he one of the key components given the state of progress of your investigation? I think you could give me a reply to this without going into the details, confidential details of your investigation. I come now to the questions of law, legal questions. You have explained that the legal points, your demonstration concerning the legal points, are determining, because you have explained that problems of international law will certainly occur, both with the Tadić case in Germany and in the Priador cases. And thus, the joining of these legal questions authorizes you to ask for deferral or to apply for deferral. So my question is the following. What are these problems of international law? I suppose that for a great part they have to do with jurisdiction or competence, but I believe that for a good deliberation of this court, the problems of competence will be posed on a regular basis for all the cases where an application for deferral is made to a given country, and thus for the tribunal, which will certainly need to supply an answer concerning the questions of competence. I would like to know if you have, at the level of the prosecutor's office, a decision, and I would like to have an answer on this. Is it a position of doctrine on the part of the prosecution, whenever a foreign country has ratified the creation of this tribunal, will this be your approach to primacy? So does this constitute your doctrine on primacy, this relating to Article 9? And these are the questions I wanted to ask in relation to this, Mr. Prosecutor. Thank you.
Your Honour, if I might deal with the questions you've raised in the order they've been raised. Firstly, is it on? Yes. Firstly, the factual questions. The witnesses are almost entirely eyewitnesses, victims who have left the area of the former Yugoslavia and who are presently, obviously, the witnesses that the German authorities have made available. Their statements have been made available to us, are in Germany, but the witnesses that are referred to being in the Netherlands, Switzerland and Sweden are in effect amongst the refugee population who were, at the time of the alleged atrocities, in Priador. I referred also to documents which are in our possession and which will, in due course, when the matter comes before a trial chamber of the tribunal, will be produced in evidence. So the witnesses are almost entirely persons who will give eyewitness evidence involving the events generally in the Priador Obstina, in the Priador region, and witnesses who will also give first-hand evidence in relation to specific allegations against Tadić. As far as the charges are concerned, we're in a position on the allegations that we already have, on the information that we already have against Tadić, would justify, in our submission, bringing an indictment immediately against Tadić on charges of grave breaches of the Geneva Convention, crimes against humanity, at least. However, in the view of our office, it would be more convenient and more proper, and indeed more fair to the defense, if all the charges against Tadić were brought in one and the same indictment. And for that reason, we are of the view that the indictment against Tadić should be brought at the conclusion of the investigations, which are well underway. In a moment, with your permission, Mr. President, I will ask Mr. Niemann to reply in more detail to the question relating to the status of the investigation. But before he does that, if I might turn to the legal points, there are a number. One, for example, will be the necessity for the prosecution, in respect certainly of any charges brought under the grave breaches provisions of the Geneva Convention, to be able to establish that at the relevant time in Priador, in Bosnia-Herzegovina, there was a situation of international armed conflict. if at the relevant times there was only an internal armed conflict, then the provisions of the Geneva Conventions would not be relevant to the alleged conduct of Tadić. The interpretation of the international conventions, of customary international humanitarian law, which would be relevant, have never received judicial interpretation because until this tribunal was established, there was no competent international tribunal to consider those matters. There will also be questions of the admissibility of evidence before an international tribunal. There will be a question also of prejudice, clearly, if the witnesses who are available to the German authorities are to give evidence in a trial against Tadić in Germany and are to be required in respect of the same and additional charges to give evidence before a trial chamber of this tribunal, that clearly would be prejudicial to the proceedings before this tribunal. So these are some of the legal questions to which I would refer, without in any way wishing to suggest that there are not others. There must be many questions of international law and practical questions of evidence and procedure which would be relevant in this regard. But I would, with your consent, request Mr. Niemann to perhaps be more forthcoming with regard to the present status of the investigation.
Your Honours, please, the position with the investigation at the moment is that it is fairly progressed. The concern that we have is that it becomes necessary for us to formulate the charges that we would envisage, not only against Mr. Tadić, but against other possible perpetrators in the region. For this reason, it's necessary for us to consider the interaction between the various potential offenders, and we see Mr. Tadić as being just one party who we would allege participated in these events. It seems to us that it is more appropriate, if Your Honours please, to present an indictment which covers a wider spectrum of the offences that have occurred, and it would be, in our submission, unfortunate that Mr. Tadić was not part of that overall proceedings that we would wish to institute. In addition to that, and there is the concern that we have about calling the various evidence of armed conflict and so forth that applies in this region, which would be pertinent and applicable to Mr. Tadić's case as well as others. And it's our submission that the need for consistency is such that it is appropriate that we make this request for deferral. And in addition to that, it is finally the interplay between the various potential perpetrators that becomes a matter of considerable importance.
Mr. President, my friend Mr. Blewett has pointed out that there was one further question that Your Honour, Judge Jorda, put, which I didn't deal with, and that's the question of the policy in respect of requests flowing from the primacy of jurisdiction which this tribunal is given by the statute. The policy that we've adopted in my office is that we certainly do not intend to ask for deferral of all cases before national courts relating or arising from events in the former Yugoslavia. Indeed, we have already taken a decision that proceedings which began within the last few days in the Danish courts, we decided was not an appropriate matter to request deferral. The human resources of this tribunal as such, we only have two trial chambers, that we have a limited number of cases which can be expected to be heard by two trial chambers. For that reason, and in principle, we have encouraged, and we do encourage, national courts, both within the area of the former Yugoslavia and elsewhere, where relevant trials can be brought, to be conducted by national courts. It's in the interests of justice, it's in the interests of this tribunal that should be so. However, we regarded that the Tadić case was different certainly to the Danish case, and no doubt will be different from other cases being investigated both inside and outside the former Yugoslavia. The Tadić case relates to a specific investigation, an important investigation, which was in any event underway in the prosecutor's office. And for that reason, there would be an overlap. The allegations against Tadić, the charges to be brought against Tadić, relate directly to potential indictments which will be brought out by the prosecutor and submitted for confirmation in due course to a judge for confirmation. So this is not in any way indicative of a policy that would induce us to suggest that there should be a deferment, that primacy should be exercised in any cases, save where there are other principled reasons for such an application.
I would like to say something very briefly. With your permission, Mr. President. Sir, in your statement, you have told that presently you are considering to issue one or more indictments against individuals who are involved in the serious violations of humanitarian law committed in Prior. According to the declaration of Michael Keegan, a policy which has commonly become to be described as ethnic cleansing was executed in Prior. In this connection, it is extremely important to remind that rape has been listed for the first time in the history of humanitarian law as a crime, and that the systematic use of rape has been an essential instrument of ethnic cleansing policy, according to the Commission of Experts and numerous human rights groups and organizations. Rape, then, is a crime under the competence of this international tribunal, and in Prior, women were raped. So it is very important that the indictments you are considering to issue clearly describe all the different elements of the ethnic cleansing policy. There will be no justice unless women are part of that justice, sir. Thank you, Mr. President.
Your Honours, we share entirely the views which were just expressed by Your Honour Judge Odio Benito. Indeed, in terms of the statute of the tribunal reflecting the present state of international humanitarian law, rape is expressly mentioned only in the Article 5, dealing with crimes against humanity. It is our intention, and it is certainly our considered view, that rape is also properly charged under the other provisions of the other articles of the statute of the tribunal. And it will certainly be our intention to follow through on that policy.
Now, let me come back again, but this is perhaps the final one. You've submitted an amended application. Now, it is, in the interest of clarity, better also to indicate the scope of what is sought in the application, the precise scope of what is being sought. Because in the event of the indictment in the German courts and the position in which Tadić stands there, you will now require the proper scope of the application.
Your Honour, in terms of the rules, the only order referred to expressly is an order calling for the deferral to the competence of the tribunal. Rule 10, capital A, provides that the trial chamber may issue a formal request to the state concerned, in this case Germany, that its national court defer to the competence of the tribunal. And we would respectfully request an order simply in those terms. We have no doubt, and we would respectfully submit, that if such an order is issued by this chamber, if in the face of such an order, for example, Tadić was to be brought to trial, if a trial actually were to begin in the German courts, in our submission, that would be an act inconsistent with an order for deferral. But whether any detailed order need be issued is a matter which we would respectfully submit would be a matter within the competence of this chamber, of your honours to determine. Rule 10b refers to a request for deferral, including a request that the results of the investigation and a copy of the court's records and the judgment, if already delivered, be forwarded to the tribunal. We have already, as I've mentioned and as was confirmed by my friend Mr. Wititsky, the German authorities have already, in response to our request, furnished us with the results of the investigation, but it may be appropriate to include in the order a request that any further investigations or any further information be transmitted to the tribunal.
Oui, je crois que
I believe, ladies and gentlemen, that the difficulty is indeed related to the change in these last few days of the position of Germany. And as a matter of fact, I turn now to the representatives of Germany to ask two questions, a factual question on Tadić and a point of law concerning the legislation. Prior to asking my questions to the German representative, I would like to say that indeed for all those who are listening to us, in order to understand thoroughly the meaning of this, to make it clear that there is no legal quarrel here which doesn't have its place in this chamber, I'd like to say that in any event, the International Tribunal can officially or formally ask national courts to defer at any stage of the procedure, This is a prerogative of the International Tribunal. This being said, I would like to turn to the German government representative and ask one or two questions. First of all, concerning Tadić himself, I believe that this change which occurred in the last few days, which perhaps not coincidental with the holding of this hearing, leads me to ask you, what is the present legal standing of that suspect? Until a few days ago, he was a suspect who, if I understood correctly, for several months had been kept in provisional custody, if my understanding is correct, and since October the German legal authorities have in fact charged him and confirmed their detention order. And I would like to ask the representative of the German authorities, because you told us that in fact it was no longer possible to leave him in that situation. But my question is, why were we not made aware of this earlier? Why was this not stated earlier? Why did you not say, well, from the point of view of German municipal law, the situation will need to be clarified in the days to come? because what happens is that on the 26th of October we heard and we learned by way of the press, sir, because you mentioned at length the desire of your country to cooperate with the work of the International Tribunal, but I must say that as far as we are concerned at the tribunal, we heard that the indictments were being prepared against Tadić. We learned of this by way of press. The International Tribunal is the guardian of the state of law, and I would like to know what the specific situation of Tadić is today with relation to your domestic law. Also, I would like to ask a question which is related to the first and has to do with the issue of legislation. You have told us that in the present state of affairs, and I take note of what you said, you told us that there were no qualifications or reservations on principle, all at the same time telling us that the legislative bodies of your countries have adopted provisions that would make it possible for the obligations of your country to be fulfilled with regard to this tribunal. Here again, I cannot but make a rapprochement with the date of this hearing. Here we are at an international tribunal created by a resolution dated May 1993, and which has been effectively in operation, even if it not function per se, since November, thus 1 year of operation. And what this tribunal would like to know is the following: what are the practical, legislative, or constitutional obstacles that have until now prevented your great country from taking all necessary dispositions in order to comply with the commitment made by Germany with regard to this tribunal? Because quite clearly, I believe that everyone here is aware of the fact that this signifies that a delay is going to be brought into the work of the prosecutor and his office, as he has demonstrated to us how important the Tadić case is with relation to ongoing investigation. So these are my two questions. One question which relates to the actual status of Tadić today in Germany, and secondly, what dispositions you can take today, even if you don't have all the elements in hand. What commitment on principle can you make? And perhaps you could give us a timetable or, to make it possible for the tribunal and the international community to have an idea of when this case, which is submitted to the prosecutor's office, when this can find determination at the level of procedure.
Thank you,
Your Honour. I should like to reply to both questions. As regards the first question, I would like to ask the representative of the General Prosecutor's Office to express his opinion on the general problem of Tadić's status. Nevertheless, I should like to make a few fundamental comments as regards this question as well. I'm particularly grateful to Judge Jorda that at the beginning of his comments he said that there is no controversy between the tribunal and the German authorities. There is nothing further from our minds, and at the end of the proceedings it will be as clear as it was at the beginning that we are not just prepared to comply with our duties, but that we are prepared to do everything in our power, as we've done in the past, to help these investigations to achieve success, and that in everything we do not intend any interference with the work of the tribunal. The fact that yesterday this indictment became known has nothing, but really nothing to do with the timing of today's hearing. The intention of the Federal Prosecutor General to carry out proceedings with the greatest speediness has been known to us for a long time, but we too didn't know that by pure coincidence the indictment was to be made yesterday. Strictly legally speaking, it hasn't been made because it only really is issued when the indictment is communicated, notified, and the accused will then become indicted, and the responsibility will then be transferred to the court from the Federal Prosecutor's Office, and then the court very will have to decide as regards its own timetable how proceedings will be taken. Meanwhile, nothing changes in our own investigations or in your investigations, and I would ask you once more to understand that this decision may have been a surprise, but this has been for factual reasons, and I must say also heard about this only today, and there is no coincidence whatsoever with today's hearing. As regards the legislative position, I would stress that the federal government has not remained inactive since May 1993 and waited for the hearing to be organized, but I would point out that, as has already been discussed in the first debates, that the statute contains a number of new items and entails a number of duties under international law, which are something quite unknown for national states, and which also requires thorough preparation. In the summer of last year, we started to prepare our legislation, and then, as you probably know, there was an encounter of the member states of the Council of Europe in Strasbourg September last year, which also was intended to clarify the question as to how these duties of international law could be implemented, and all represented member states at the time came to the conclusion that because of the fairly concise nature of the statute, it would be advisable to wait for the issue of the rules of procedure before national implementation rules would be issued, and this is what we've done. We know that the final wording and text of the rules of procedure has only been available since this spring. This again does not mean that we've remained inactive since that time. I myself and my unit, my office, have presented several revised drafts, and in fact then the decision of the court, or the prosecutor rather, for to apply for the deferral of the proceedings against Tadić has caused a speeding up, as far as we were concerned, in so far as the proceedings which were only intended to be started off after the new legislative period were started off in September with all possible speediness. But this was only caused by the application. Before that, I must say that we did not have the impression that there was any duty which had to be fulfilled immediately, which we could not already comply with. As we've said, in the meantime, as discussed, we've fully complied with a number of requests by the tribunal. Today, I presented to the prosecutor the statement by the main witnesses in the Tadić case, and we will continue to do so. The only thing we cannot yet do, according to our prevailing law, is the formal transfer of an accused to the court, something which is not required, and also the securing of such a transfer by our own warrant. But this is all balanced out by the fact that in our national law we can fulfill all these requirements in a way, I would stress this, which will have no negative effects on the procedure of this tribunal. I may perhaps ask Mr. Griesbaum to state the facts on the present situation of Tadić. Your Honours, prosecutors, the Federal Prosecutor's Office had assigned the indictment against Tadić on the 3rd of November, and I should like to explain why this timing was chosen, and I would like to refer to the legal situation in Germany. We have a legal provision that after a 6-month duration of detention, with intervals of 3 months, the federal court will examine the question whether this detention is still justified. Duško Tadić has been in detention for 9 months. In August, the first examination by the Supreme Court took place, which decided to continue the detention, but insisted that proceedings and investigation should be conducted speedily. This meant for us that investigations should be concluded, if possible, within the next 3 months. These 3 months expire on the 18th of November, and it is unusual in the Federal Republic that such detention without indictment lasts for more than 9 months. An indictment is an act which requires much work, much evidence. We've been working for several weeks on this indictment, and that the fact that it then was concluded on the 3rd of November 1994 is understandable with regard to the expiry of the term on the 18th of November. We can't make the indictment just before the end of the expiry term, because the documents have to be sent to the court in Munich, and then these documents are notified, and a position has to be taken by the court to the Supreme Court. It is a question of courtesy in the proceedings that the relevant court in Munich, the Bavarian Regional Court in Munich, is given 2 or 3 weeks' time in order to prepare itself. So it is a pure coincidence as regards time that this indictment was transferred by us to Munich yesterday. And I would ask for the indulgence of the tribunal that I cannot say anything about the details of the indictment. We have the principle that the public hearing only deals with the points of the indictment once the accused has received the indictment. This has to be translated into Serbo-Croat so that he should not hear through the press what is being charged with. I would just summarize. We accuse Tadić in 15 cases of genocide, 10 indictments of murder, at least 32 victims, and at least 7 cases of grave serious bodily harm. That is the extent of the charges brought against him. Thank you.
I think this concludes the public hearing of the application. The trial chamber will now rise and reassemble at 2 p.m. prompt for the decision.